Do you remember when the Sauber F1 team and the driver Giedo van der Garde kicked off the 2015 season with a legal battle over the Dutchman's position at the team? You don't have to be a mathematician to work out that 3 into 2 doesn't go. But back in 2015, it didn't stop Sauber from signing 3 drivers to pilot its F1 cars. After a miserable 2014 in which the Swiss team failed to score points, the team was struggling to survive with a reduced Constructors' Championship payout, and let go of drivers Adrian, Sutil and Esteban Gutierrez at the end of the year. In their place, the team signed ex-Caterham driver Marcus Ericsson and GP2 driver Felipe Nasr, who had just finished third in the second tier category. But reserve driver Giedo van der Garde also laid claim to the seat, and infamously emerged in the Sauber garage at the Melbourne season opener following an Australian court ruling that he had the right to drive for the team in 2015. And although van der Garde never raced and later settled with Sauber over the controversy, the legal wrangling hardly looked good for the team. So what exactly happened? Let's get into the story of van der Garde's battle with Sauber. Now today, Giedo van der Garde is known for his light-hearted approach to social media, but he was also a highly capable driver who had long been on the periphery of F1. The Dutchman had been no stranger to contractual wrangles before, having signed a deal to become the Super Aguri team's test and reserve driver for 2007, before defecting to the Spiker team a couple of months later. Super Aguri presented the deal with van der Garde to the Contracts Recognition Board, but eventually appeared to settle with Spiker to allow him to move teams. Following a few years in GP2, van der Garde returned to F1 with the Caterham team in 2013, before joining Sauber as its reserve driver for its miserable 2014 season, in which it failed to score points for the first time ever. Van der Garde was believed to have one of the Sauber race seats guaranteed for 2015, as the team had apparently triggered an option to promote him and was bringing funding from a number of Dutch-owned businesses to make that a reality. But when Sauber announced its lineup of Ericsson and Nasr for that year, van der Garde immediately launched a case with the Swiss arbitration tribunal, which agreed that he had a case. Ahead of the Melbourne season opener, van der Garde took his case to the Supreme Court of Victoria on Monday, March the 9th, hoping that he would be granted the opportunity to drive. Sauber in turn prepared its defence, represented by Rodney Garrett. Sauber could not allow him to race, Garrett said. It would be reckless and dangerous to do otherwise. It would result in an unacceptable risk of physical harm or even death. However, there are numerous examples of a driver put into a car with no testing in F1, and van der Garde's lawyer Tom Clark made that exact rebuttal in court. After all, in the season before that, Andre Lotterer and Will Stevens were late call-ups to the Caterham team with no testing, so there was even a recent precedent to fall back on. The decision was deferred to Wednesday, March the 11th. On that day's hearing, the Supreme Court Justice Clyde Croft ruled in favour of van der Garde, upholding the claim of the Swiss tribunal. Furthermore, Justice Croft added that the ruling applied to the whole of the 2015 season and not just the Australian Grand Prix, much to Sauber's chagrin. Sauber immediately appealed within hours of the decision to be heard on Thursday the 12th of March, but it was dismissed. A statement read out of court explained that the appeal was not in the interest of justice, and the appeal is dismissed because we see no error in the reasons of the trial judge. To add salt to the wound, Sauber was also ordered to pay van der Garde's legal fees. On the precipice of the Grand Prix weekend, Sauber had 3 drivers for 2 seats, a court battle still yet to be resolved, and with more legal action pending. The team had allowed van der Garde to don Ericsson's overalls for a seat fitting, but was unable to drive in the opening practice session, having not had the opportunity to renew his super license. So Ericsson and Nasr then were available to take driving duties for FP1, but neither car ventured onto the circuit for the session, perhaps wary not to participate and risk having its assets seized before van der Garde had got his super license sorted. Sauber did eventually get some running in during FP2, with Ericsson and Nasr, who had arguably been caught in the crossfire, placing 11th and 15th in the session. Kaltenborn explained, "We have a very clear idea of what we did. The outcome here is different, and that's all I can say about it." But by the Saturday morning on the 14th of March, van der Garde and Sauber held a discussion, and van der Garde agreed to drop his rights to race in the Australian Grand Prix to pursue further talks with the team. Of course, van der Garde's contract still stood, but this allowed Ericsson and Nasr to continue driving for the team over the weekend at Albert Park. Van der Garde explained that he decided to give up his legal rights to the Melbourne drive with respect to the interests of F1 and the FIA, but added that his management will continue talks with the team to find a solution to his contractual issues. Nasr added that it had been a tough atmosphere within the team amid the legal dispute, but nonetheless qualified an impressive 11th place for the Australian Grand Prix to take some of the sting out of Sauber's weekend. The Brazilian driver finished 5th in his first ever F1 race, with Ericsson making it to 8th to secure a double points finish in a difficult few days for the team. Despite the haul of points, Sauber still had the small matter of Van der Garde's contract to deal with. 3 days after the Australian Grand Prix, Van der Garde released a statement declaring that he had reached a settlement with Sauber, in which his contract was ended by mutual consent. Van der Garde explained that his driver contract for 2015 was triggered in the first half of 2014, in which he paid a sponsorship fee up front to help the team counter its cash flow issues. He added, "Sauber's financial decision making in this case is bizarre and makes no sense to me. I am not at liberty to discuss details, but Sauber paid significant compensation to avoid honouring the contract they had with me." This compensation fee was reportedly around $16 million, including the money he had paid to the team in 2014. Further legal action was avoided as Van der Garde felt that with the team's precarious financial state, it could potentially sink them, something that F1 and the FIA wanted to avoid, and potentially ruin the careers of Ericsson and Nasr. However, Van der Garde also felt that the case had highlighted the need for regulations to safeguard the driver's contractual rights in F1, recognising that perhaps his own time in the championship was over. Sauber disagreed with Van der Garde's account but refused to expand further to avoid a mud fight via the media, and elected to direct its full focus back on 2015. But Van der Garde was not the only driver involved in legal action against Sauber over its 2015 driver decision. Adrian Sutil, cut loose from the team at the end of 2014, took his own case to the Supreme Court of Zurich over unpaid money, having made his displeasure at being booted out of the team clear. Sutil also argued that he had a contract with the team. Seeking over $2 million from the team, the Swiss court upheld Sutil's legal argument too in early 2016, while a separate case was ongoing regarding the terms in which he lost his race seat. It's unknown what the settlement with Sutil's case was, if any, but this comes as a lesson to all F1 teams out there. If you only have 2 seats, maybe just sign 2 drivers to them.